turn it on.
Hey everybody, how's everyone doing today? Today you've got me and Rachel. Hey Rachel. You don't usually get the two of us together, but you guys got lucky and now it's us. So we don't have any of the tactical teachings today. So we are just going to go in and answer as many questions as we can possibly get to. So with that, you ready to kick it off, Rachel?
Let's go. I'll take the first one. All right. Cecil Dixon asks, hello, I'm 93% service connected. Somebody's doing their calculated ratings. I'm trying to get an increase on a 0% IBS rating I received in April. My symptoms are very bad, but not well documented. Also, I had an acceptable clinical evidence exam instead of C&P. So meaning the examiner like reviewed the records rather than actually asking you any questions or having you go to an exam. My decision letter tells me what I was missing. How do I get new and relevant information for a supplemental claim? Also, do I need multiple doctor visits? Should I wait for months to file? Okay, that's a great question. And that's something I think we hear a lot is, I have these symptoms. They are bad, but they might not be in the medical record. Either maybe it's not something, well, with IBS, you might not want to be getting in the car and going back and forth to the doctor. You might not be able to. Things like migraines, I know a lot of times I talk to clients and they're like, well, the doctor really can't do anything. So what's the point of going? But keep in mind that medical evidence isn't all that VA can consider. You can also submit your own lay statement and testimony as well as witnesses, friends or family members maybe who see how it affects your life. I would recommend for intestinal or for gastro issues. We do this with headaches as well. We will send our clients a diary, which is, fancily named for like basically just a sheets with grids on it that you can use to document each day you have symptoms, what those symptoms are, how long they last, how you treat them. And that information is honestly way more useful to rating than an ACE examination for C&P. Ursula, what would you say?
I would say exactly what you said. I think getting a statement is one of the best ways to kind of bridge the gap between your everyday symptoms and what might or might not be in the medical record. And, you have up until a year to file. So if you want to make a diary, things like that, you can certainly do that. Just don't miss that appeal deadline. But yeah, I agree. Statements and lay evidence is usually the best way to do it. All right, Marty. I went to basic training in 71 for 5 months at Fort McClellan. We marched everywhere. Now at 78, I have CLL, which is a type of leukemia. I never served in Vietnam or any other presumptive area. Retired in 2000. Are you having any luck connecting CLL presumptively to Fort McClellan? Since this would not involve back pay, how are you compensated at H&P if you help win a claim such as this? Well, I'm glad you asked this question. So as far as Fort McClellan specifically goes, what we know is that there were herbicides that were used on that base. Each attorney here at Hill and Ponton is very well versed in Fort McClellan claims, and we have an entire system that we do in order to prove exposures that are at Fort McClellan. So we are having luck connecting things specifically like the presumptive conditions that would be specific to Agent Orange or the herbicides in Vietnam. You have to remember the herbicides in Vietnam are no different to the herbicides that were used in Fort McClellan. They have the very same toxic dioxin that's in them. It's not easy to always win these claims. VA is very inconsistent with how they're granting them and rating them and things like that. So it is, you typically are in for a little bit of a fight. And it's really important that you have all of the evidence. Here, I know we have all of the evidence to help you win that claim. So, I mean, if you're not having any luck on your own, I would certainly reach out to an advocate that does have evidence to help you substantiate those claims. As far as the way that compensation goes, Fort McClellan claims are one of the claims that we take without having a decision already. And the reason is we have a system. So when you come to us without that claim, we'll file it for you. If it's granted on that initial filing, we're not going to take a fee on that. We're not allowed to take a fee on that. And anybody that's charging you for a fee on an initial claim is not supposed to be doing that. So that should be a big red flag if you're paying up front for anything like that. So on initial claims, we can't get any compensation. We have had some claims get won at that initial level. We put all of our evidence in, and then sometimes they do get granted right off the bat. For the most part, we are going to have to appeal because VA doesn't like to grant these at the regional office, and we typically have to take a trip up to the board. And so you're looking at least a year of that claim kind of going through the initial stages, getting the appeal, going to the board, waiting for a decision. And so we would be compensated from when that claim was filed, any of the appeals that were made, and then to the date that they grant that benefit. Of course, we'd be looking at things like your ratings and your effective dates and maybe some other things in the file that you may not know were issues. So we're going to do a lot more than just look at the Fort McClellan claims, but that's kind of how it works. If you did serve at Fort McClellan and you have conditions that are also presumptive to Vietnam era veterans that were boots on the ground or Blue Water or Thailand or Guam, and you were at Fort McClellan, I would very seriously think you should consider filing for those conditions with an advocate who has experience with Fort McClellan. Rachel?
Couldn't have said it better.
Here you go.
All right. Another step 25 asks, I filed an HLR in April, higher level review, and requested an informal conference call. I haven't been contacted yet to schedule it. What steps should I take to follow up? Will they issue a decision without the call? Okay, HLR in April, what is it, July? It's normal. I say 3 to 4 months generally is what we see. It can take longer, it can be shorter, but generally that's the turnaround for a higher level review. So it's normal if they haven't contacted you yet, they likely will within probably the next month. If they haven't by then, you should call the VA's main number and inquire, because they should not issue a decision without the conference call. Since you requested it, they're not supposed to go forward with anything until they talk with you. One thing you can do, I suppose, if it's been more than a month from now and you haven't heard, it gets into be August. I would also make sure that the VA, when you call them to check, make sure they have your correct contact information to contact you for the informal conference. I have seen that a couple times where the information is wrong. Ursula, are you seeing anything different as far as timeframes?
No, that seems about right. And usually when they call, sometimes they'll email you as well. They'll email you something from a website called Vera, VERA. And so you have to go in there and then schedule your calls. So be on the lookout for that as well. You may get an email that you then have to follow up with. But no, you're exactly right on the timing. I wouldn't be too concerned at this point. Next question. I think we're ready. Maybe do we have more to say? You got anything else? There we go.
There we go.
Atlanta Vet. Okay. Hello. I have a direct review appeal at the board for Barry Half Steps since September 2025. Just checking on to see When do you think I will get before a judge, or even am I even close yet? Thanks. So being September of 2025 in the direct review lane, I would say that you are getting close to being in front of a judge. Things are not taking 3 years like they used to. But I also can't say that, oh, you're coming up. I would say about a year. Because I've also seen them still take 3 years. But what I would do is, you should have gotten a docketing letter in September when you filed. With that docketing letter, there would have been a waiver on the kind of the back page of that letter that you'd want to fill out and fax back or mail back to the board. And it's essentially a waiver of additional time. So what that means is, there's a rule that if your rating decision was in February of 2025 and you file an appeal, VA cannot make a decision until at least a year later, when you might be able to switch your dockets. So you would have to be waiting at least a year. So if, in this case, if your rating decision was August, you filed in September, you're waiting till at least August before you get that decision if you don't fill out that waiver. I don't really know the name of the waiver. I call it the Williams waiver because that was the name of the case. But I would definitely get that in and waive the additional time, so you're not just waiting for that year to be up. For people that are filing waivers, especially with our clients, I am seeing decisions in about a year to 3 years. Definitely more on the year side, but I don't know what the board's doing up there as far as docket numbers and docket orders. They're not working in docket order. I know that's for sure. So I wish I could give you a better answer, but I think you're getting close, and definitely get that waiver in if you haven't done that already.
And I would also suggest, not sure your age or not, but if you have any appeals waiting at the board, this is for everyone. If you have any appeals at the board and you are 75 or older, you're supposed to get priority processing and a quicker turnaround. So it should be supposed to be an automatic thing where you automatically get advanced with at your 75th birthday, but they don't always do it. So it's always worth checking. Although I do agree with Ursula, about a year is what we're seeing on the direct reviews. So you're hopefully coming close. Okay, it's my turn. AMDR asks, I recently got denied service connection with my knee, and the VA's rationale that it was caused by another condition that is already service connected. Yep. So I want to claim the knee as secondary to that other condition. So you need to refile a new claim, or can I do a supplemental appeal and submit that I want to change the claim to secondary based on the VA's own rationale? I actually think I would do a third option. I do higher level review, and meaning you don't need to add any new information in. It's what's already in the file. You can switch your theory. So it sounds like they were looking at it. They said it's not primary. It's not directly due to service. It's due to your service connected condition. So we can't grant. So in this higher level review, what I would do is just point out it's already in the VA's rationale. They said this knee condition is due to this condition. I'm asking for secondary service connection. And that, don't bother with you don't need to do a new claim, and you don't need to worry even about a supplemental appeal because you're not adding anything new. You're using their existing rationale. So I'd say higher level review, you get a quicker turnaround. Like I said earlier, hopefully 3 or 4 months. It's no guarantee it's still VA. I still see them mess things up, but I think that would be your best option to get that sorted out. You agree, Ursula?
I agree 100%.
Okay.
James Robinson, if I currently have a VA attorney, do I need to fire them before getting a new one? So yes and no. So when you are already represented by either an attorney or a BSO or, DAV or whoever, a representative, when you get a new attorney and you sign up with them and they fill out a VA form 22A, it's going to automatically revoke the previous attorney's access to your file, and VA will no longer see that previous attorney as your representative. Would the right thing to do to have a talk with your attorney and be like, hey, I'm done? I would certainly do that, because you've got issues with the fees associated with it. So depending on what kind of fee agreement you're on, let's say you have a VA attorney and they filed all of the evidence and you're on a 20% fee agreement with the VA, and you hire a new one, and then a decision comes in, VA is going to have to do this calculation to figure out which attorney gets what money. So you're not going to be, you're going to put it into an area where VA is going to have to figure out who gets paid what. What you may want to do is, if you have an attorney, is try to get a fee waiver from your previous attorney, because you don't, and if you have not just a 20%, let's say you've got a 30% contract and then you go into a 20% contract, you're still going to, you could still potentially owe that other attorney the 30% fee agreement that you went into with them. And then the other person is going to get 20, and it's going to leave you with not a whole lot of your retro. So I think communication is kind of key in this. Most attorneys will do fee waivers for clients if they're wanting to go somewhere, unless they've spent money on something like a medical opinion and the attorney has put their own money into the claim, they may ask for that back. But so there's a lot of things that kind of play into the decision that you make on whether or not you're going to tell your attorney. But ultimately, even if you go to a VSO, anytime a 22A or just a 22 is filed, essentially the old attorney no longer has access to your file and you have essentially fired them. So
the important thing I would say is less like them, you could, as Ursula says, you can file the representation form with anyone at any time. I would suggest, I think probably most attorneys, I know we do, have a policy where if a client has previously been represented, we have to have a fee waiver to come with it. For the reason Ursula is mentioning, if down the line you get benefits granted, then VA's got to do a lot of calculation as to who owes what. It just gets really messy. There's more time spent on the VA doing your calculations than them actually like looking at your disabilities. So I know we require a fee waiver. I would definitely recommend, if anyone is looking to switch attorneys, if you're with someone who have not a VSO, someone who is charging, I would recommend talking with them so you can get that waiver ahead of time. Okay, Michael Hawkins 721. In October 2010, I was granted TDIU for 40% for back strain, 20% bilateral sciatic radiculopathy, 20% each leg. Today, I was awarded SMCS effective September 2025. Also, oh boy, 20% bilateral restless leg syndrome, other rated 60% for heart, 50% mental health, 20% right shoulder, 10% hypertension, and SMCK. All right. Filed BVA direct review appeal for aid and attendance denials. That was going to be my next suggestion, aid and attendance. Go ahead with the first denial. Oh boy, this is a little bit hard to answer when the questions are like this, because it's hard to track. We can only see so much. So whenever you guys are doing your questions, just please keep that in mind. All denials, but I think we can answer this regardless. So essentially, this aid attendance has been denied 4 times so far, all because he didn't meet the scheduler requirement. Filed a legal argument with BVA to review the entire historical record and to grant statutory advancement SMCO, advancement R1. Also asked for effective date in attendance to go back to 2012. Okay, a lot of questions. I'm not going to be able to, we can't really answer all those. We can't answer as far as what the advancement, what the jumps would be to get up to SMCO, because I'd have to be seeing your whole file in front of me. That being said, the board is much better at doing the statutory advancements. Like if you, for example, they give you aid in attendance for one condition, or just say, so for example, say your back and your radiculopathy, say they threw in your restless leg syndrome in there too. right? If those are the conditions that cause you to need aid and attendance, and that's shown, and then you've got these additional ratings, 60% here, 50% here. The board is much better about applying all of the ratings that need to be done. The regional office, you'll find, will often just do like one when maybe you need 4 different jumps. I can't answer as far as the effective date for 2012 because it just depends. Has it been continuously appealed? It didn't sound like it. If there hasn't been a continuous appeal, you're going to have trouble getting it that far back. It's not to say they didn't make an error. I'm not saying it's impossible, just based on the facts. That's hard to say. Could we go to, no, you know what I was going to tell you also, you noted the prior denials were because you didn't meet the statutory requirement. That is the regional office language, and that's only at the regional office you're going to hear that. There is no statutory requirement, rating requirement for aid and attendance. It's based on your need. The regional office says you need to have 100% rating, and that is not right. It's not in the laws. It's not in any case law. It's in their manual that they have at the regional office. So for that reason, I'm going to say I bet you're going to be a lot more successful with as far as aid and attendance, because there is no scheduler requirement, and the board knows that, and they're not going to give you that crappy reasoning. Ursula, anything else to add on here? And we're kind of scattered.
Yeah, so we're kind of all over, but having the SMCS means that there's at least one disability at 100 or TDIU based on one condition. But when you're taking a look at this and you're taking aid and attendance to the board, you first have to get L, right? So you're here talking about O to R1 with effective dates. I think when you go up to the board and you're arguing your aid and attendance, it's important to argue what conditions you need aid and attendance for. And you want that to be based on the least amount of conditions, or alternatively, you need aid and attendance for these conditions as well as these conditions separately. And that's how you may get, to like how you argue that aid and attendance. What the board is most likely going to do is grant aid and attendance based on certain conditions. The regional office will then go back and they will figure out, they'll incorporate it and they'll give you an effective date. So the effective date and the rating is really going to be determined by the regional office. You will most likely, once the regional office implements whatever it is they come up with, you are likely looking at going right back up to the board to say, we don't have the right level of special monthly compensation. They only gave me L.5 and I should be at O, which equals this, and they only gave me this effective date. So you've got way too many issues right now. Right now, your issue is SMCL for aid and attendance based on certain conditions. And I would just make sure that you have the least amount of conditions in there to require that aid and attendance so that each one of your other conditions can be a jump up. That would be my advice to you. But don't expect the board to come in and say, we're going to A, give you aid and attendance, B, we're going to give you R1, and I'm going to give you an effective date. The regional office has to set that stuff first, and then you'll probably be back at the board. And I would just go directly back to the board too. I wouldn't even mess around with the regional office, just straight up.
They're not good at SMC.
Not at all. All right, Sky Pod Images. I'm 50% mental health as of June 2026, depression, anxiety diagnosed back in 2010 from Gulf War. Cognitive memory loss started in 1998 and progressed. I have had many MRI, CT scans, 4 neuropsychology tests over 25 years, and doctors stated it's undiagnosed as they're not sure what's causing. For a new claim theory, how do I keep the VA from combining this into my existing mental health rating? This should be an undiagnosed illness caused by Persian Gulf War and rated separately. All right, good question. So there is no rating code for undiagnosed illness, right? what they do is they take the symptoms of that illness and they're going to rate it. A lot of times, cognitive issues fall under the mental health umbrella. So when you look at the rating formula for mental health, things like memory loss, fatigue, depression. Can you go back one more? Let me see some of the other symptoms he talked about. Go back one more. Right. So the memory loss, that is actually part, like mild memory loss is part of the mental health diagnostic code and the symptoms that are listed in there. So I think you may need to go for a higher rating and have them include things like the memory loss in there. There also isn't a rating criteria for memory loss. Even dementia, which is, profound memory loss, is still rated under the mental health diagnostic code. So it sounds to me like your rating just isn't appropriate for the issues that you're having. If there are other things that, the undiagnosed illness, you've got the multi-symptom illness as well. So if part of, the mental health is you're being rated for a lot of fatigue and tired, like they need to look at all of those symptoms and rate you appropriately for it. So Mecabe, which is, the medically unexplained multi-symptom illness, and the undiagnosed illnesses, they can get very complicated very, very quickly. But just based on what I'm seeing here, I would certainly go for an increased rating, especially if you've got a lot of those memory loss issues. So, yeah. What have you got, Rachel?
I completely agree. That's kind of a frustrating thing with VA as far as especially mental health or any kind of cognitive issues, that they all rate them under the same umbrella. And it's like everything from, like Ursula says, dementia to depression to schizophrenia to cognitive TBI residuals. It's all rated under the same umbrella. The important thing is, just like Ursula notes, the memory loss, that is considered in those symptoms. So the increased rating would be the way to go. Just like Ursula said, fatigue, any other associated symptoms that you can bring in, you should still get, if that can be service connected, you still can get a rating for those, but they're going to be rated under separate diagnostic codes. So they might be rated under a similar one for chronic fatigue, might be under the diagnostic code for chronic fatigue, or you might have, I don't want to speculate.
Gastro, yeah, all kinds of stuff. Migraines,
Skin
vertigo.
issues. Yeah, so those should all be rated separately, even though it's not necessarily, it's like part of a Gulf War illness, they still rate them according to their existing criteria. But that was a good question because I see that a lot. Okay, Echo Ranger says, hello, at in attendance for my migraine, sleep apnea, and major depressive disorder. My doctor filled out on my I'm going to guess that's 2680, that I have a need also for aid attendance for my peripheral neuropathy, knees, and back. Okay, so we've got migraines, sleep apnea, or respiratory, and then mental health. That's what aid attendance is all given for. And then your doctor also says you need it for these physical issues, neuropathy, knees, and back, which are all service connected. Okay, just making sure I had that. Next question, is it possible to get a second aid attendance, or should I file for SMCO? All my conditions are service connected, static, and on my aid attendance form. Good question. Yes, I know that. 2680 is the aid attendance form. So if you can go back to the first question, please. Okay. Your question is basically, should I file for another aid attendance or should I just file for SMCO? To get to SMCO, you need to file for another aid attendance. So what you need to do in order to get to SMCO, you got to make sure that the reason VA gave you aid attendance is specifically for these reasons. And they'll usually say it either in the decision or in like the CMP exam. Usually they'll say what it's for. Sometimes they'll say all your service-connected conditions. And in that case, then you have to start separating them out. It gets a little more complicated. But assuming that VA has specifically said migraine, sleep apnea, depression, that's what aid in attendance is for. If you're service connected for these other physical conditions, and they're not considered in your aid in attendance, you can absolutely ask for consideration for aid in attendance for these specific disabilities. And you can even note, separate and distinct from these disabilities that already qualify me for aid in attendance. You're going to have to be really specific because VA doesn't do it. Like, they're not just going to, oh, I see what he means. Like, yeah, we'll read this in correctly. They won't. Probably you're going to write it specifically and they're still going to mess it up. But you need to be very specific that you're seeking an additional SMCL award for aid in attendance for PN, knees, and back. And then from there, once / if VA does end up granting aid in attendance for making additional finding of aid in attendance for those issues, at that point, you're going to want to bring up SMCO. What you need to do is show how those are distinguished. This award for aid in attendance is based on these specific issues. This one is based on these specific issues. Without considering one or the other of those, you still need aid in attendance. And put them together, that's very big. That gets you to SMCO, can get you to R. Ursula, any thoughts on that?
No, I mean, yeah, exactly what you said. As long as they're very distinct aid in attendance, make sure that 2680 doesn't have any of those other conditions that you already have aid in attendance for. VA is probably going to come back and be like, oh, you're already aid in attendance. And they're not going to get it. You'll probably end up at the board. But once you have 2 L's, you go to O. And if you need aid in attendance, which you do, you go directly to R1. And this is just a personal thing. And, Rachel, I'd love to know what you do. I don't ever specifically ask for a certain type of SMC or level of SMC. I know normally when I file my appeals, I'm just saying, a higher level of SMC. And then in my argument, I lay it all out. Because, and I don't know. What do you do? What do you guys do over there? What do you do?
Yeah, no, it kind of depends because in some instances, so say a case like this, we specifically know what we're looking for. And we're like, he needs another award of SMCL for this reason. If it's something where we're still developing it, yeah, then we might generally say higher level of SMC. And especially if there's multiple ones that I'm addressing, what I'll do in the argument is I'll do A, B, C. A, loss of use of feet. B, aid in attendance for this. C, combining the steps. So pretty similar thing. Because a lot of times whatever SMC we're asking for, I mean, just like here, ultimately the goal is R1. That's what they're looking for when they're getting 2 L's to O to R1. But a lot of times that end SMC is like, we can't say that the veteran qualifies for it yet. What we're asking for instead is the higher level of SMC that will then get them there. So yeah, same kind of approach, because I don't want to ask for R and they're like, no, you only have 1 L. I want to ask for a higher level and then lay out what it is. So same approach sounds like.
Yeah. So
now
start with the L. Yeah, start with the L and try to get the L first and ask for the L. Once you have that, it should mathematically just kind of happen that way. And if it doesn't, that's when you just line it out. So.
Grace Smith, shout out to Nate and Benji, always doing a wonderful job keeping up.
Really yeah. Do. Snaps. Are we snapping? Is that what we're doing? Yeah, okay. That's what we're doing. All right.
Yes. Whenever we say go back to the next question, that's not magical. That is Benji keeping up with us.
Oh, wait. This one's my one. I'll take this one because the last one was yours. All right. Interesting agreement with National Academies of Science, Engineering, and Medicine concerning toxic exposure. Is that it? Is there anything else to that? So I think are you talking about the current, evidence research that they're doing on the toxic exposure specifically for neurodegenerative muscular diseases? If you're watching, could you answer? Because that's the only one that I'm really familiar with right now. essentially the PACT Act required that VA do some additional development on some of the conditions that were in there. And if we're talking about what I'm talking about, and one of the things they did was they contracted with the National Academies of Science, Engineering, and Medicine to find out whether certain exposed veterans, like the ones that were exposed to burn pits, whether or not that exposure to burn pits has a higher likelihood of leading to certain neuromuscular degenerative diseases, things like Parkinson's, IBM, inclusion body myositis, and there's a big list of them. Those are the ones I'm most familiar with. And so they're currently doing work to figure that out. Once they get all of the results, we'll likely see some kind of regulations that come in that may make some more things presumptive for people who are exposed to burn pits. Or we're just going to get better guidance on what kinds of things might have an association with the burn pits. From what I understand, there will not be a report out until July of next year on it, at least July of next year. So I don't know why at least July of next year is when the report's out. I've never known anybody to be like, we'll get it to you. No, it was at least after July of next year. So we don't even know when we're getting it. We could be getting that report in July of 2030 because it won't be before July of 2027. But we are keeping an eye on it because it's going to be pretty substantial depending on what some of these results come back with. So if you're talking about that, it is an interesting agreement. I don't understand why it takes 2 years at least to come up with some things. But again, it was only for very specific conditions related to specific exposures. But we are keeping an eye out, and when we know something, we will let you know for sure.
Okay,
So,
Charlie Swift says, hello, H&P team, 1 of 3. The back appeal was denied at the VA. Lawyer picked up the claim and filed, okay, it was at the BVA. Lawyer picked up the claim and filed with the Court of Appeals for Veterans Claim. They said, saying claim was denied due to judge's error, not referencing all back issues noted in medical record/claims file. He states from the file, I should have been granted SMCL because the record states my daughter helps me with bathing. The back claim has been open since May 2020. Any thoughts? I'm not clear. It's not 100% clear. Did the court return the appeal and say the judge made a mistake, or that was your attorney's argument? I'm not 100% sure. It's not clear on that. Either way, so even if the court said it or if that's your attorney's argument and the court eventually agrees with it, what would happen? So can we go to the first question here? The back. Okay, so it is service connection for your back. Okay, so if the court returns that, then the board makes their decision. Even if it's a denial again, what you can do is do a supplemental appeal and add in more evidence. As far as the aid and attendance, it's not something that the VA is going to necessarily, if they grant your back claim, they're not necessarily also going to grant aid and attendance. But if you need it due to your back condition, while this is all going on and you're waiting to get it back from the court or waiting to get another decision from the board, go ahead and, we said earlier, form 2680. That's the VA form that a doctor fills out based on your need for aid and attendance. I would definitely recommend, if you can't get one of those done, at least file a claim for aid and attendance and tell the VA, ask the VA, like say, I think I need aid and attendance, here's what I need. I can't get a 28, what am I saying, Ursula? 2680 filled out by a doctor. Please give me a CMP exam to get this form completed. And the reason I'm saying do it all now, don't wait until the back claim comes out, because there's a specific rule with aid and attendance effective date that essentially the rule is generally going to be from the date of your aid and attendance claim. But if you later get a decision that grants benefits for a period that goes back prior to your aid and attendance claim, and that has to do with the issue that you need aid and attendance for, so you're back, say they grant that, and it goes back to 2020, even if you filed your aid and attendance claim in 2026, because it's tied up with the back claim, if you file it while it's still pending, it will attach with the back claim. And so if it does, if you can show, I do need an attendance due to my back, it ends up getting granted and it's been this continuous appeal, you could then tie that aid and attendance back to your initial continuously pursued back claim. Ursula?
Yeah, I mean, I agree with all of that. One thing I just want to make clear is, so when you take something out from the BVA and you take it to the CAVC, you are now no longer dealing with the Department of Veterans Affairs. Essentially, you're out of the VA, and this is a specialized court that was set up specifically for veterans claims with federal judges that sit up there. In order to take something from the board to the CAVC, there has to be an issue in the law that was done by the judge, not anything that has to do with the facts of the case. So depending on where that lawyer is, whether he's just argue it, there's multiple things that could happen. It doesn't seem like the judge has made a decision yet, but there are a lot of things that can happen. A lot of times we see something called a joint motion for remand or joint motion for partial remand. And what that means is that it goes up and they agree at the CAVC that this judge didn't look at all of the issues that were listed and not all of the evidence was reviewed. That's likely what you're going to see here is a joint motion. It looks like it's a reasons and basis issue, which means it would go back to the BVA and they would have to fix the issue that they had. Or the attorney you're working with could try to go for a reversal, which means that they're going to go and they're going to sit in front of a judge and try to reverse whatever decision it was that judge made. Most of the time, we're not seeing that, not for something like this. So you, at any point, once it goes back to the BVA, if that's what's going to happen, your attorney that's handling your VA claims can submit additional arguments and evidence and make sure that that aid and attendance is listed in there, that you need that kind of aid and attendance. So I do agree with Rachel, do file for it, get that in there. The other thing people don't know is once you have a board decision and you file to the CAVC, you can file a supplemental claim. You can have those claims in two different places at the same time. It's not something that we do very often because it can get very messy when things come back down and effective dates can get really, really messed up. So if you haven't filed for aid and attendance, I would go ahead and get that in and then, wait for whatever is happening up there, because even if you're granted the aid and attendance and they service connect your back down here, then you can just work on an effective date issue over here. So yeah, I do agree. But yeah, we see that a lot. Some of the board judges are just not looking at the entire record. Sometimes we put in medical opinions, arguments, and they're just not even mentioning those things. And the thing is, when a board judge denies a claim, they have to look at everything that was in there and give you an explanation on everything that was favorable and why they didn't grant it. So when you get a board decision, do read it and make sure that your statements were addressed, your lay statements were addressed, that any medical evidence in there that's favorable was addressed. Because if they haven't done that, then they haven't done their job, and you can get that turned around at the court. The other great thing about the court is you don't have to pay the attorneys for that unless you have like over I think 2 million in assets. So if you want to file that, typically the government's going to pay the attorney to take those cases. So you're not out anything. If you see that decision's wrong, you can reach out to someone who practices in that area and get those decisions turned around. I've seen a huge uptick in the amount of cases that we're having to take to court because some of the board decisions are just that bad. That sounded like a little bit of a rant session there, didn't it? Well, we're not ranting today. We're not doing it. But
Oh, come on. I was getting ready.
So, I mean, I don't think just because the board denied it that you're over. There are attorneys out there that specifically handle those CAVC appeals. And most of the time they'd be very happy to help you and it doesn't cost you anything. So just want to throw that out
That's
there.
always a plus. One thing, sorry, Ursula, you said, and I've just been like stuck on it. I wanted to know, and this isn't necessarily for Charlie here, but just in general, talking about board decisions and reviewing them. Something I see a lot with board decisions that are, what am I trying to say, like insufficient. They don't go over all the evidence, is look to see what they did cite, because I'm thinking of a specific example with a gentleman who we're looking to go for like loss of use of fee or higher ratings for his neuropathy or something like that. And in the denial, the board listed all of these records in which he could do all these things himself and he was walking without assistance. But then those records were from like 2016 and 2018, and this is a decision in 2026. You know, a lot has changed since then. So that's another thing, is if you know for a fact, like you have additional medical records you've submitted, just like Ursula's saying, review the records, see what they're citing. And if they're saying like your condition is better than it actually is because they're looking at old records, that's definitely something to note and to correct. Okay, mini rant over.
Yep. So I think we just ranted about board decisions and how they're not super great all the time, and you should appeal them, because just because it's coming from the board doesn't mean that it's right. So,
or that the final decision is completely over in a case. It doesn't mean that.
Yeah, I agree. Is this me or you? Who took? I'll go.
I think it's you.
Okay, thanks. You helped me with 100%. Well, I am glad that us here at H&P could have done that. But you did it, and that's amazing. Congratulations. Now I'm helping a buddy to get him 90%, confused about denied tinnitus. The reason denied, the VA medical opinion found no link between your diagnosed condition and military. Okay. A service, and neither occurred or caused by service. Favorable findings. The evidence shows a qualifying event. Injury had its onset during service. VA concedes exposure to hazardous noise during service. Your VA examination provided a diagnosis of tinnitus. Am I on the right track to have him do a higher level review? I'm going to answer that, and then I'm going to go in a little bit deeper. Yes, you are on the right track to have him do a higher level review. So we see this quite a bit. So when you file an original claim or an initial claim or a supplemental claim, those claims are going to the first line raters. These people really don't know what they're doing. And I don't mean to say that as a horrible thing. Like, these are the least trained individuals that are handed a book and they go, hey, here, handle these claims. And VA law is very hard and it's difficult. And if you don't have a lot of medical experience or understanding and legal experience, it can get very hard. And they're kind of just rushed through it, and they don't understand literally what they're doing. But service connection requires 3 things. It requires a diagnosis, an event in service, and a nexus. So what it looks like here is that they're saying that you don't have that nexus. You don't have anything tying that diagnosis and that event to the disability that you have now, right? So that's the thing that they're really, their reason for denying. They're saying, okay, yeah, you have a diagnosis, and yeah, we know that you were exposed to noise, but we don't think that your tinnitus that you have now is because of that noise exposure. Insert knee condition, insert hypertension, whatever condition it is, we see that a lot in those favorable findings. And what they're saying is, we don't think that what you have now is because of what happened. I think you are absolutely right to do a higher level review and point that out. The best thing to do is to make sure that you put out there, as long as it's not new evidence, if you're going higher level review, that there's nothing else that happened in this person's life that could have caused the tinnitus. It is because of that. Continuity of symptoms. Now, continuity of symptoms does not mean continuity of treatment. It does not mean that you have to have gone to the doctor every single year for the tinnitus. It can be, since military service, these things happened and nothing else has happened. When I left the military, I was in an office. There wasn't a whole lot of work. Or when I left the military, like not a whole lot of noise. When I left the military, I worked at the airport guiding the planes, but I wore protective headgear, so I know it's not from that either. So I would go higher level review, see what happens. Sounds like a pretty quick turnaround. And again, like I said, insert any condition. You will likely get sent back, either granted or sent back for more exams, or denied. My next stop after that is I would just go directly to the board into the evidence lane with a statement or something. Or if they do a DTA, submit a statement then. But yeah, we see this all the time, but you're missing one of the elements. Well, they say you're missing one of the elements. You're probably not, but that's what they're saying. So just fix that issue.
Completely agree. I can't recommend doing a statement enough, especially when they say no continuity of symptoms. They'll say that all the time. You know, it's ridiculous. So saying, you know, this noise exposure I had during service, which they've conceded, have your buddy know, my ears started ringing during service or right after that event and haven't stopped since. Just like Ursula was saying, no, like, did you work in quiet environments? Did you have hearing protection? Just really, it's the statements are about getting the evidence that's like not in the medical records, just your day to day. It's getting it in the file so that VA can actually consider that.
I think statements are so underrated. They are a very underrated tool that people sometimes don't use. Like, they can also be hurtful sometimes, but if you know exactly what your issue is and what you're trying to do, this can be the game changer when it comes to ratings. So, not always service connection, just depending on what element of service connection is missing. But statements are underrated, and I think people should write more statements, especially figuring out, like, once you know what that specific issue is. Statements have won cases for us before. So it's been the thing that kind of tips it over. So for all of you out there, write a statement every once in a while.
Absolutely. And particularly in situations like this, where they know you know, he's got tinnitus, he's got the in-service noise exposure, but just mysteriously there's a third element missing. I'll see that same thing when a veteran has a right knee condition. Their right knee was treated in service multiple times, but suddenly, mysteriously, the current issue and the issue from service just don't seem to be related. A statement explaining, I've had these issues since then, it's gotten worse, it's continued, I've always had these issues, that is what's needed. So especially when you know that you have something documented in service and you have a diagnosis and they're still denying it, statement.
Exactly.
I think we've got time for one more. It's my turn to read, I think. All right. Derek C asks, can I file PTSD if my car was shot up by another military individual? Well, that certainly could be a stressor for PTSD. Were you in the car? Were you like at risk of harm? First thing is a diagnosis. Do you have a diagnosis? Second would then be to establish the in-service cause. So if that's something that happened during service, you need to have it. For PTSD, something needs to be documented. So for that, I don't know, police reports, documents from your service records, and then you of course have to show the nexus that we're talking about. If you do have the diagnosis, you've got this event that was documented during service. Generally what then you need is a psychologist or psychiatrist noting the relationship. That one is actually pretty simple. Ursula, am I overlooking something really big?
No, I mean, if you were in service and you were in a car that was shot up, it doesn't even need to be another military member. If you are on active duty and your car was shot up and you have mental health symptoms because of that, yeah, I think you should file for PTSD or mental health if you have a diagnosis of PTSD already. If you don't have a diagnosis of PTSD, I would probably open up that diagnosis to be acquired psychological condition and let them figure out what your diagnosis is based on your records and when you show up for your exam, because you may just have anxiety, right? And there's a different set of rules, same set of rules, but you don't want to get denied because you claimed PTSD, but you only have anxiety. So I would probably kind of open up the diagnoses there. But there, there is also a misconception that, it has to, like, if you are playing football in the military, like you're out there on your time off and you are playing football and you break your shoulder, that has nothing to do with what you are doing for your military job, your military. If you're active duty and you do something like that, you can file for that condition. It doesn't have to, PTSD does not have to be because you were in combat, because there was a sexual trauma or anything like that. Anything that happened while you were on active duty that could cause some kind of mental health condition, you can file for. You can file because, there's all kinds of reasons to file for. So don't think that it has to be something major that happened if something caused you to have a mental health condition based on, doesn't have to be. Okay, I'm done there. All right.
Maybe we could do one more. Let's see. Not a four-parter, Benji.
Yeah, give us one more. All right, I'll do this one. Why can't I get my records? FOIA requests filed 226 still pending. Well, I wish I had a really great answer for you for this. FOIAs take forever. So a long time ago, that was the only way we could get your VA, your C file. And it would take a year from the time we signed on representation to when we would receive like a copy of the claims file. I don't know how long it's taking now. Maybe not as long, because as soon as we take on representation, we get access to the online adjudication site that has the whole claims file, and we can go and download it specifically from there. Unless it's a DIC claim, for some reason, we're not getting access to those, which is an issue all in itself. We can't download those files. But for just regular, so I don't know what to tell you other than to wait. You could possibly go to a VSO, have them, I don't know if they would do this though, get a 22A signed, have them get your C file, put it on a CD and give it to you. I don't know if they would do that. I know, with my clients, if they want their C file once I have it, I certainly do send it to them. But I don't know if even all attorneys do that. I feel like it's your records. You should be able to get it. So maybe try a VSO. If you have an attorney or a representative, get it from them because they have access to it. So yeah, sorry. Do you have anything?
Yeah, and I wouldn't say it's crazy to still be waiting. It's a normal amount of time. Like, it's not completely unusual. They haven't like lost your request. They're just very slow. So that's normal. Benji noted you got one more question. Let's see if we can do it. 90 seconds. All right. I'm 100% TDIU. I also have ischemic heart disease and hypertension that I have not filed a claim on. Should I file for a future DIC spouse claim? This is a very thoughtful spouse. Yes, you should. If it's something, especially if it's something that you can get service connected for, even though you're at 100%, say hypertension is a really great example, as is heart disease. Those are killers. A lot of people with those conditions, that does end up being one of the causes of death. If you're service connected for those conditions and that contributes to your cause of death, that's on the death certificate. Your spouse has no problem showing that was service connected. I would do it just because that's peace of mind for you. Yeah, it's not going to change your rating, but if you can go ahead and get service connected for that now, that's one less thing for your spouse to worry about in the future. That helps ensure that you can still make that service connected link, even if you're to pass away during it. I think that's anything to
I
add.
agree. Nope, I
All
agree.
right. Good work. I think we've done it.
We have. Thank you guys so much for hanging out with me and Rachel. And I think you got Brian and Carol next week. I think. I don't know. No, not Brian and Carol, Matt and Carol. I don't know. Well, you'll have someone. Thanks for spending the afternoon with us, and you'll have a wonderful rest of the week.
You served your country, and now another challenge awaits. Getting the VA disability benefits you've earned. Too many veterans face endless delays and denials, and they shouldn't have to. At Hill & Ponton, we know the system and how to fight for you. Scan now to download The Road to VA Compensation Benefits, a free guide from Hill & Ponton, trusted VA disability attorneys. For over 30 years, we've helped veterans secure the benefits they deserve. Our free guide helps you avoid common mistakes and know when to call for backup. Scan now or visit hillandponton.com.